Hello and welcome back. My name is Jordan Anderson, and I am the producer of new docuseries Laufer's Law Only If You Like Perfect. I want to thank everyone for watching our first episode. Please stay tuned for our next episode, which features three female attorneys at the law firm discussing very important topics. Thank you.
Hello, my name is Alexis Laufer. I am a partner at Laufer, Dalena, Jensen, and Doran in Morristown, New Jersey. Our firm specializes in family law matters, including divorce, child custody. We handle domestic violence matters, and we also handle wills, trusts, estates, real estate, personal injury, municipal, and civil matters. Today, I am going to give you an overview about child custody laws in New Jersey. This is often the most emotionally charged aspect of any family law case. Many people hold off on getting divorced because they don't want to or cannot comprehend life without their children 100% of the time. It's one of the greatest fears of the unknown in any divorce or separation. What's going to happen to our children? Where will we each live? What will our parenting schedule be? These are very serious and important questions. The idea of uprooting your children is often enough to have people shy away from moving forward with a divorce, even though you know you need to do so. So I tell my clients a couple things. Number one, children are resilient. It's better to have your child grow up in two households, with each one filled with love and happiness, rather than one household where there's toxicity. After all, our children grow up to model our behaviors. If they grow up in a household where there's constant discord, they'll view that as normal. And when they grow up to become adults, they're more likely to model that behavior in their adult lives. So while divorce is certainly not a fun process, my goal is to educate my clients to remove that fear of the unknown and give them a clear understanding of New Jersey custody laws so they can envision what their lives might be like if they decide to move forward with a divorce or separation. Knowledge is power. Being educated can often empower people to take a deep breath, move forward, and remove themselves and their children from what may be an unhealthy relationship and provide everyone with a happier life, including your children. So let's talk about custody laws in New Jersey. In New Jersey, the guiding principle for custody determinations is the best interest of the child. So the court is not focused on what is fair to the parents. It's focused on what arrangement will provide your children with the best health, safety, happiness, and overall development. Courts evaluate a number of statutory factors, including the parent's ability to agree and communicate, the children's relationship with each parent, stability of the home environment, and when appropriate, the children's own preferences. In fact, just a few months ago, in January 2026, the New Jersey Senate bill was passed, a new Senate bill was passed amending the New Jersey custody statute, which really brought some significant changes to how courts will deal with custody. Specifically, the amendments focus on increasing the weight of a child's preference if they're of sufficient age, child safety, and there are also certain new limitations imposed on therapeutic practices. So in New Jersey, there are two types of custody that I'm going to talk to you about today: legal custody and physical custody. Legal custody, think decision-making, okay? Legal custody refers to a parent's right to participate in major decisions affecting their child. This includes medical decisions, what doctors will they go to, educational decisions, choice of school, are they going to attend private school, public school, selection of extracurricular activities, religious upbringing, etc. So in the majority of cases, absent extreme issues, the parties will share joint legal custody, meaning both parents will share in decision making. The extreme circumstances I'm referring to that would warrant sole legal custody are very extreme, so you need to understand that. We're talking about substance abuse, major mental health issues that impair a parent's judgment, or in some cases has left them incapacitated, if they're admitted to a medical facility and they're not available to take care or make decisions for their children. If a parent is imprisoned, situations involving child abuse, domestic violence. In some cases, a parent may be found to be intentionally trying to alienate or turn their children against the other parent. And in that case, there are situations where the court may, in fact, transfer from joint legal to sole legal custody or residential custody to the parent who is not engaging in those alienating behaviors. That being said, the majority of cases do not fall within these extreme circumstances, and legal custody will be joint. Many clients will say to me, well, that's not fair. I've always handled everything for our kids. I've made all the day-to-day decisions. I've always picked their doctors, managed everything with schools, picked their activities. So what I tell these clients is the shift can be challenging, but in the end, you have two parents. And these decisions do need to be made by both parents jointly. So that's legal custody. Let's talk about physical custody. This refers to where a child lives on a day-to-day basis. One parent may be designated as the parent of primary residence. The other may be designated as the parent of alternate residence. You can share joint physical custody, but at the end of the day, I counsel my clients not to focus too much on these terminologies and rather focus on what will become your parenting schedule. So, parenting plans, let's talk about that. They're often extremely detailed and tailored to each specific case. You want to make sure that you retain an experienced family law attorney when you're talking about these parenting plans. There are many factors that come into play. We talk about parents' work schedules, maybe the parents work shift work, night work, maybe one parent's not employed and available more after school while the other parent is only available on weekends. We'll discuss and settle on summer schedules, vacation schedules, who will drive the children back and forth, communication between the parents, communication between the children. There can be step-up schedules. Maybe the children are very young when you first get divorced. Child custody and parenting time is always modifiable. So it's, again, important that you work with an experienced family law attorney when you are negotiating your parenting schedule, because there are so many nuances that go into the proper drafting and negotiation of your schedules. And that being said, the majority of research does show that children thrive best in a 50-50 setting. However, if there are concerns, as I said, about a parent's mental health, drug use, abusive behavior, you need to raise these issues to your attorney, because there are different ways that we will then modify or take positions regarding the best parenting schedule for your child. So in conclusion, custody law in New Jersey is not about winning or losing. It's about structuring a plan that serves the best interest of your children. While the process can feel overwhelming, especially at the outset, the reality is that most cases do result in parents both playing a meaningful role and an active role in their child's lives. Legal custody is typically shared, major decisions are made jointly, and parenting schedules will be tailored to fit each specific family and your needs. So the courts focus on stability, continuity, making sure the children's relationships remain strong with each parent. And listen, divorce is a major transition, but it doesn't have to be a negative one for your children. With the right structure, cooperation, guidance, families can create a new framework that allows their children to thrive. Thank you.
My name is Alyssa Clemente, and I'm a partner here at the law firm of Laufer, Dalena, Jensen, and Doran, located in Morristown, New Jersey. You've previously heard from Bill Laufer about an initial consultation and the information that we ask you to provide during that meeting. Sometimes during the initial consultation or in the conversations that follow, we determine that you may need additional professionals on your team in the form of an expert or something similar, or you might need another evaluation to be conducted as part of your divorce. Just like Mr. Laufer talked about the team of lawyers working on your behalf, we sometimes need to engage one or more experts to be part of that team for you. The experts provide us, as your divorce lawyer, with valuable and necessary information to help us advocate for you and guide you through that process. Experts can provide a variety of functions in the divorce process. Sometimes they might just provide us information. As an example, as is sometimes the case with a real estate appraiser, perhaps parties don't know what the value of their real estate might be. In that case, we could get an appraiser to be retained to determine fair market value. And that might be all the parties need to move their matter forward. They may not need to use an appraiser for anything else. Other times, we might need a report to help bring your matter to a close, to settlement. Those reports could be brought into and referenced in mediation or other settlement opportunities. And sometimes when settlement is not possible, experts are brought in on your behalf to testify at the time of trial. In all of those instances, experts help our team to assist and guide and advocate for you. Oftentimes, we find that when we meet with clients and get underway in the divorce process, people may not be prepared for potentially needing another expert in their case. Our initial consult or the conversations that follow might be the first time a client has heard that they may need another expert. So today I'm going to talk to you about those potential experts that you may need to hire as part of your team and what purpose they serve. We could probably have an entire segment on every type of information, but I'm going to give you a brief overview of each kind. Oftentimes in a case, a client might need to hire a real estate appraisal. We might be appraising the marital residence. That's the phrase we use to describe where you live during your marriage. It might be a vacation home or an investment property. It could even be a piece of commercial real estate, perhaps owned as an investment, or if parties own a business, it may be where the business operates out of. A lot of times clients will say, what about a comparative market analysis? In fact, sometimes they've already brought a comparative market analysis to us. We call that a CMA. That's typically a free service from a potential realtor who has some interest in selling the property. And while that might be a great first step, it's not the same as a certified appraiser and can't be utilized in court in the same manner. Formal appraisals can be used in your divorce in a few ways. Oftentimes now people have a general sense of how much their house is worth, but maybe you don't. And if you don't, it could give you that general sense. Knowing that information allows our clients to determine if it's best to sell the property, if they want to buy out their spouse's interest in the property, or not. In terms of how the actual appraisal process works, real estate appraisers are licensed professionals and they provide the appraisals. They'll go to the location where the real estate is located, do a visual inspection, and provide us a formal report. As you will hear is the case with all of our experts, parties can either decide to use one person jointly, a joint expert, or you might decide to hire your own expert as your own individual expert. While there's no hard and fast rule, and there are always exceptions, appraisers are typically charged on a flat fee, and they're often the least expensive of the possible experts. Another type of expert that we discuss with our clients are employability experts or vocational experts. They come into play when one party is possibly unemployed and there's a dispute about what they could earn if they had a job outside of the home. Or sometimes they come into play when it's being argued that while somebody has a job, they're in fact underemployed and can earn more than they do at their current employment. Every case is different. While every employability expert has a slightly different process, there are some general parameters that most of them follow. They often request that the party being evaluated prepare and complete a questionnaire in advance that will look to educational background, prior work history, and prior compensation levels. Then they'll meet with the party in question, the person being evaluated, and they'll conduct an interview of that person. Once they've gathered the necessary information, employability experts also issue written reports. Again, they assist in either settlement or, if necessary, a trial. Similar to real estate appraisals, employability experts often charge a flat fee. It's usually a little more expensive than a real estate appraiser, but it's still on the less expensive side as compared to other types of experts. I know that you've heard earlier from Ms. Laufer about potential custody issues. In any cases where parties have unemancipated children, custody and parenting time issues must be resolved. Sometimes parties come into our office and they know exactly how they're going to settle the issues. And if both parties are on the same page, then an expert won't be needed. But more often than not, custody and parenting time is an issue in dispute in a divorce. People often can't agree on issues like how they're going to timeshare with their children or who's going to make decisions on behalf of their children. In those cases, we'll discuss with you, our client, the potential need for a custody expert to be a part of your team and whether they need to perform an evaluation to address whatever custody-related issues might be in dispute. Similar to employability issues, custody experts are going to gather a lot of information in advance. They're going to ask biographical information about you and your family. They're going to want to know about any court orders which might already be in place or any other documentation that you deem necessary for the custody evaluator to know. And after that stage, they're going to get underway with their meetings. They're going to meet with each parent. Even if the expert is only one parent's expert, a custody evaluator is going to meet with both parents. They'll also meet with children. If you have young children, a custody expert might evaluate your children while they're interacting with you in a safe space. If you have older children, a custody expert may sit down directly with your children and speak to them one-on-one. In addition to the parties and the subject children, custody experts will often talk to third parties involved in a family that we refer to as collateral witnesses. Those could be extended family members, friends, teachers, coaches, doctors, therapists, anyone else who might have relevant information. And just like other experts, you can retain your own expert or you can get one jointly with the other party. Custody experts and evaluations also often take a significant amount of time. Not only are those experts very busy individuals, but there's a lot of interviewing that goes on into the process. And finally, for today, we often add forensic accountants to our team to assist you. They provide a wide range of reports, but most often we see two things: cash flow analyses and business valuations. Cash flow analyses come into play typically when someone is in a W-2 wage earner and we need to otherwise evaluate their income. And business valuations are generally utilized when a party owns a business or is part of a family business. They also interview parties, and in this case, they'll really look into books and records and make a determination. Of course, there are other types of evaluations and experts that we may add to your team. You might have a unique vehicle or a collection that needs to be evaluated. The possibilities are endless, but these are the most common. Depending on the facts and circumstances of your case, these experts can be critical in helping us assist you as you move your divorce forward. Thank you.
My name is Hailey Vogt, and I am an associate attorney with law for Dalena, Jensen, and Doran here in Morristown, New Jersey. You've heard from some of my colleagues, and our firm often specializes primarily in family law. However, we do offer other services, including but not limited to estate planning, estate administration, and guardianships. Today, I'm here to speak with you about guardianships, and more specifically, my role as a court-appointed counsel for guardianship applications filed on behalf of alleged incapacitated individuals. Under our rules of court, specifically Court Rule 4:86-4, the court is required to appoint counsel for an alleged incapacitated person with respect to a guardianship application being filed by a petitioner. My role as a court-appointed counsel is unique in so much that I am required to zealously advocate for my client. We will discuss that a little bit further, but I want to briefly begin with how this guardianship process starts. So step 1, the filing. The filing begins in Superior Court Chancery Division probate part, where a verified complaint, amongst other necessary pleadings, are filed by a petitioner. Within that complaint, the petitioner is seeking for the alleged incapacitated person, also known as the AIP, to be deemed incapacitated, and as a result, for the petitioner to be deemed the guardian of the AIP's person and/or estate. Often, a petitioner is a child of the AIP, a spouse, a sibling, or a facility. Being deemed the guardian of the AIP's person has to deal with making personal decisions on behalf of the AIP, as well as medical decisions. Being deemed the AIP's guardian of the estate is making financial decisions on behalf of the AIP. From my experience, I have often seen complaints being filed where a petitioner is seeking to be the guardian of both the person and the estate of the AIP. What is being requested simply depends on the AIP's needs. To provide some backdrop, the reason why the complaint is being filed in the first place is often because the petitioner is, according to the petitioner, the AIP lacks the capacity at this time or never had the capacity to sign off on a power of attorney, authorizing another individual to make and manage financial, medical, and personal decisions on his or her behalf. A common example is a petitioner being a parent and filing a complaint on behalf of the AIP, who in this example is an 18-year-old who was born with a developmental disability. Another example is a petitioner being a husband filing a complaint on behalf of his wife, who has been since diagnosed with dementia and never had the ability to sign off on a power of attorney. Inclusive of the necessary documents along with the verified complaint are 2 affidavits from either 2 physicians and either one physician as well as a licensed psychologist in support of the petitioner's application. Each of those affidavits are required to be submitted no later than 30 days prior to the filing of the complaint. All the requisite pleadings are governed by Court Rule 4:86-2. Step 2, the appointment. Once all the requisite pleadings have been filed by the petitioner and the court is satisfied with the sufficiency of the complaint and the supporting affidavits, the court will enter an order fixing hearing date and the appointment of counsel for the AIP. The contents of this order is governed by Court Rule 4:86-4. However, to briefly summarize, the hearing date is exactly what it sounds like. This is the date in which the hearing is scheduled to determine whether or not the AIP lacks in capacity. The appointment of counsel is also exactly what it sounds like. I, as a court-appointed attorney, am appointed to serve as the AIP's counsel. The court's order should, amongst other things, indicate that I'm required to personally interview the AIP, examine and have the ability to obtain medical records of the AIP, make inquiry of persons that are interested parties in the matter. Within that same order, I am also ordered to prepare a written report of my findings and recommendations and to file said report at least 10 days prior to the hearing. Step 3, the investigation. Once I've been appointed, my role really begins. I often start with making an introduction to the petitioner and thereafter making arrangements to meet with the petitioner as well as the AIP. In most cases, I often start by interviewing with the petitioner and then thereafter the AIP. The order in which I conduct my interview, however, really depends on the facts and circumstances of the case. Starting with my interview with the petitioner, I am often trying to get information as to how the guardianship application came about and the overall need for same. Depending on the AIP's needs, I often try to ask questions to the petitioner to try to find out how much they've been involved in the decision-making process thus far for the AIP. For example, if the AIP needs assistance with his or her ADLs, I'm asking questions such as, how does the petitioner assist with the AIP's bathing, feeding, clothing, and so forth? Same is true with respect to asking questions of the petitioner as to how he or she manages the AIP's medical affairs as well as financial affairs. Depending on the facts and circumstances of the case, the petitioner may be the best suited person to explain to you the AIP's needs, since at times the AIP is unable to communicate to you what his or her needs are, his or her ability to understand the questions being sought of him or her understand concepts and really appreciate the severity of the decision-making process. Moving on with my interview with the AIP, I always start by introducing myself and explaining my role as his or her court-appointed attorney. I also go through whether or not the AIP understands the basics of what a court is, what a judge is, what a guardianship entails, and what an attorney is. I try to also ask very basic questions of the AIP to gauge a better understanding of what he or she may understand. Common examples are whether or not he or she knows the date of his or her birthday, how to spell his or her name, what the weather is like, and how to dress seasonally appropriate for the weather. During my interview, it really is crucial to understand whether or not the AIP understands what a guardianship entails. And it's important that you explain that really clearly to them. And also it's important to understand, it's important to ask the AIP whether or not he or she wants the petitioner to serve as his or her guardian. And if the AIP wants a petitioner to serve as his or her guardian, what that means with respect to the AIP's ability to really no longer be able to manage his or her personal, medical, and financial affairs going forward. As previously mentioned, my role as the AIP's court-appointed counsel is to advocate zealously for what the AIP wants, unless that position is patently absurd or it poses an undue risk of harm to the AIP. Lastly, I make inquiry of others, so I will contact other interested parties. For example, in a case where the petitioner is the husband filing an application on behalf of his wife, I will contact the child to see whether or not the petitioner is suitable to serve as the guardian in this case. Step 4. Once my investigation is completed, I will submit a report to the court no later than 10 days before the hearing. Ultimately, my report is often the most influential document the judge reads before rendering a decision. For this reason, it's my opinion that you be as detailed as possible as to what your investigation encompassed, as well as setting forth what your client wants, as well as your recommendations with respect to the guardianship. Step 5, and the last step, the result and the judgment. As governed by Court Rule 4:86-6, if the judge finds by clear and convincing evidence that the AIP is incapacitated, a judgment of incapacity is entered by the court. If the judgment is entered, the guardian must qualify at the county surrogate's office, and after qualifying, the surrogate issues letters of guardianship to the petitioner, now the guardian of the AIP. In closing, as a court-appointed counsel, your role again is to zealously advocate for what the decision of the AIP wants. By also serving as court-appointed counsel, your goal is to ensure that if an AIP was to lose his or her right, it is done so in an appropriate and thorough manner. Thank you.
Wow, Billy, it was really a pleasure to hear from your well-informed female lawyers here.
Well, you had a trifecta. You had Alexis, Alyssa,
and also Hailey.
And they really hit home runs. I got to tell you, they did a great job on the custody, the
expert witnesses,
yeah, and the guardianships.
Yes.
What great show. So everyone should enjoy that.
Only if you like perfect.